expands the scope of what can happen. For example, right to privacy, it says subject to law, it does not say subject to an act of parliament. So it can be so that the courts have expounded right of privacy in a certain manner, then those precedents or those judgments of the court will also be treated as having the effect, or this right will be construed in accordance with what the courts have also held. But it does not exclude Parliament's right to make an act. So my submission, Lordships, is, and your Ladyship, is that the term law as provided in Article 191 does not preclude or does not exclude the Parliament's right to legislate. My Lords will notice that this provision has not undergone any amendment ever since the Constitution has commenced, Article 191, and so has the preamble. So while Parliament was acknowledging and making its obligation, imposing an obligation upon itself and all other organs of the state to fully secure independence of judiciary, Parliament at the same time did not give up its right to legislate on matters which may relate to regulating practice and procedure of the Supreme Court. And in my CMA, I have, and I walked your Lordship through the history of how the pari materia provision of Article 199 has evolved over the years. And I had submitted that it is in fact the executive's role which was eliminated by the Parliament from this process in 1973, which the executive through the President has had prior to the 1973 Constitution. But what it did not do was, it did not give up its own right.
But if you draw this analogy between what was happening prior to the 1973 Constitution, where the rule-making power was subject to previous approval, Governor General, President, so on and so forth, that power which you say was in the executive branch, and that has now been taken away. Is this, if I've understood you correctly, that power was of what I may call a passive nature. In other words, the President, Governor General could not have initiated rule or exercised rule-making power. It was simply you, Supreme Court, make the rules, but they've got to pass muster with the executive branch before they come into effect. So if this is the analogy that you are drawing, then why ought not the law-making power that you say vests in Parliament in terms of the word law, why should that also not, although it remains there, and as you say it has never ever been exercised prior to this particular act, but drawing the analogy now between the previous approval, why should that also not be regarded in a passive sense, in the sense that it is not an enabling provision, but simply something that Supreme Court has to keep in mind when making rules?
Understood, sir. Barring Government of India Act, all other subsequent constitutional frameworks, constitutions that we have had, there was always legislative power. The rules were always subject to law and constitution.
Our 56 Constitution.
56 Constitution, in fact, went a step ahead.
Uski language farak hai na?
Ji, 177 said that until an act of Parliament is made in this behalf.
That's a different language.
So it was actually, it went a step further.
What happens after?
And then subsequently 62 and 72, it says subject to the Constitution and the law with the prior approval of the President. So what is happening here is, and barring Government of India
Government of India Act.
Government of India Act was totally prior approval in his discretion, and that's about it.
No, but Government of India Act did not have any legislative engagement at all.
Yes.
So what I'm saying is, if you look at it in the historical context, and I'm now focusing on the analogy that you are making, that previously there was the executive plus the legislative. The executive was purely passive as far as I can understand. So why should not, on that analogy, the law-making power or the law part of it also be regarded not as an enabling power, but as a whatever restrictive, limiting power, or whatever in whatever sense.
One reason perhaps could be that till 1972 or when the 1956 rules were made, because there was a prior approval of the president already there, the legislature chose, and in fact, in 1956, because third schedule applied, until such time it applied when the parliament actually made these regulations, to the exclusion of, in fact, the Supreme Court under the 1956 Constitution, it did not. So there was, the Parliament chose not to act. What I am submitting, my lords, is that Parliament's choosing not to act, or choosing not to act, and I'll come back to the provisions of the Constitution which use term Act of Parliament.
Why did you exclude 19A?
19A is, my lord, because I'm only focusing on 19A, of course. 19A, I'll be coming to it.
Similar language,
I will
subject to regulation and reasonable restrictions imposed by law.
And I'll be coming to it. I'll be coming to it because the 2017 Act.
So why do you want to exclude it from?
For now, I'm just focusing on one thing, which is that the subject to law as used in 191 in fact confers legislative competence. And I'm drawing parallels between 191 and these provisions, but I will be coming back to Article 19A and such other provisions in, for example, 6.3, Article 6.3 of the Constitution, which also confer legislative competence, and my lord is aware.
Are you saying that the subject to law used in Articles 14, 20, 22, 28 are of a different species from the term, or maybe it's not exactly same term as used in Article 19A?
No.
Okay.
What I mean to say is that merely using subject to does not in any manner take the competence away. For instance, Article 6, Clause 3 says that a punishment for high treason will be provided by law. The term is used provided by law, and in Article 19A it says imposed subject to such restrictions or regulations as imposed by law. All of these, interchangeably, they confer legislative competence, and the 2017 Access to Information, Right of Access to Information Act 2017 draws its legislative competence from 19A. It does not draw its legislative competence from any of the entries 1 through 57 of Part 1 of the Federalist or Federalist. The term law, my respectful submission, my lords and your ladyship, is it includes two sources. One would be a positive law, which in this case would be an act of parliament, and the other would be precedents, binding effect of the legal precedents. Generally speaking, this is what the term law has come to be understood in our jurisprudence. And the binding effect of the precedents is duly acknowledged under Article 189 and 201 of our Constitution. But what it does is, it does not exclude an act of parliament.